Here's your focus question for today. We're going to have one slide, and then we're going right back to the Supreme Court packet. So you can copy this in your notebook. How did Supreme Court Justice Earl Warren help solidify the civil rights movement? All right. So the other Supreme Court justice that we have worked on, the only other one you need to know for this class is John Marshall. Now, this is the usual point where I ask as a review, what was the consistent thing that John Marshall always ruled on? All right, well, if you think back to the early 1800s, what he did was always strengthen the federal government. All right. Earl Warren is the Supreme Court justice. He's the Chief Justice from 1953 to 1967, and he is always about increasing rights. All right. So Warren is known for increasing the rights of individual citizens. We'll look in the many cases that he does. Basically, people are going to get more rights and power under him. Okay, whether it's specifically a group of people or whether it's, just a general group of people. All right. And specifically, the biggest group is he's going to attack the Fifth Amendment. And the Fifth Amendment has to do and basically solidify the rights of an accused person. So if you get accused of a crime, you get your Fifth Amendment rights. And the problem is not many people know that, including people that are much older than you, don't realize what the Fifth Amendment rights are. So essentially, just as a reminder, just sitting here in your room, you have your first four amendments. Okay, you have the right to freedom of speech, the right to privacy, no search and seizure, things along that line. Okay, sitting there in your room right now, if you've not been accused by a crime by law enforcement, then you don't have your Fifth Amendment rights right now. But the second you get accused of a crime, you get your Fifth Amendment rights. So we're going to talk about that. So this is Earl Warren. All right, let's take a look at how some of these cases go. All right, so the music's going to be playing again, but I'm not going to do it again. You're going to be responsible for writing down this one, this one, this one. All right. We've already written down Brown versus Board of Education, so we don't need to do that again. All right. But I'm just kind of showing you that is under Earl Warren, where that is obviously going to help the rights of African Americans, okay, and students, okay, and Roe v. Wade. This is not an Earl Warren Supreme Court case, but we do need to spend some time on Roe v. Wade because it's probably one of the most controversial Supreme Court cases specifically today. All right. And we'll talk about what that is. I'm sure you've heard about it before. All right. So let's go through Earl Warren's first major Supreme Court case, which is Miranda versus Arizona. So this is usually the time where I ask, raise your hand if you ever heard of the Miranda rights. Okay. The Miranda rights are what happens if you are placed under arrest and a police officer is going to say to that particular person, you have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney, blah, blah, blah. Okay. This is going to help the rights of an accused person. Now, before 1966, if you got arrested in 1930, you were not read your rights. But you obviously, according to the Fifth Amendment, which passed in 1790, you have those Fifth Amendment rights. But what happens is a lot of people don't take Mr. Panio's 8th grade social studies class, or they don't remember things, okay, and don't fully understand their rights in our society. So what happens is police officers were able to coerce and to try and were able to get answers out of people because they did not know they had the right to remain silent. They did not know they had a right to a lawyer. They didn't know their rights. So all the Miranda rights is pretty much a summary of what the Fifth Amendment is. They're reading you your rights as an accused person. Okay? So there was a situation in Arizona. I forget the guy's first name, but his last name's Miranda. He gets arrested. I believe he was a Hispanic immigrant, didn't speak much English, and basically within interrogation gave up all of he didn't remain silent. He basically gave up all of the things that linked him to a crime and eventually got thrown in jail because of it. All right, and in this case, his lawyer was very good because his lawyer kind of argued that basically he didn't know his rights. Okay, since he didn't know his rights, how could you because since he didn't know his rights, he got in trouble. That's a problem. So what was the outcome of the case? So this is what you're obviously writing into the box in your Supreme Court case packet. Okay. All people that are arrested must be told their rights as an accused person. So if I got arrested, all right, and the police officer forgets to read me the Miranda rights, then I could literally walk out free. It doesn't matter what I'm accused of. All right, and obviously that police officer is probably going to be fired or get in a lot of trouble because they just blew the case right there. All right, but that's probably an unlikely thing because the police officers are trained to read the Miranda rights, and this is something that comes directly from the Supreme Court case under Earl Warren. All right. And as you can see here, what group did it target? Well, the rights of the accused. All of these are going to have to do with rights in some way, your rights as a person. And this was a huge focus because this is during the civil rights movement. Okay. And during the Cold War, where this is a huge focus. All right. Not the same Supreme Court case, but a different one that also has to do with the rights of the accused. All right. So Gideon versus Wainwright. This is a pretty famous example where there is there's Gideon. I forget the first name again, but basically a very poor individual. And he could not afford an attorney. So he literally had to defend himself in court. But listen, if you know the Fifth Amendment rights, you have the right to an attorney. Okay, it doesn't matter if you're poor or not. They can't deny you getting an attorney. So courts need to provide an attorney for the accused, even if they can't afford one. All right, and that is something that is reinforced in 1963 in a Supreme Court case, Gideon versus Wainwright. Now, if you want to go on trial and you want to waive your attorney and not go up there with them, that's fine, but you have to sign off on that. All right. If you cannot afford an attorney, one will be provided for you. That's a part of the Miranda rights, and that's part from the Supreme Court case. And what that means is there's what's called a public defender that probably isn't the best lawyer, but knows enough of the laws, okay, to basically get you the best type of lawyer you can afford, so to speak. And this goes to show, the more money you have, the better lawyer you can get, but at least someone's going to have a lawyer if they can't afford one, okay? And lawyers, if you're going to be a lawyer, they get paid a lot of money in the future, but they are very expensive, all right? So now this is all under Earl Warren. Let's move to Tinker versus Des Moines. So Tinker versus Des Moines has to do with students. Okay, there was a situation in Des Moines, Iowa, okay, at a school. And basically what was happening, just giving you a summary of the case, there were students that were wearing anti-Vietnam War shirts. All right, and their school had a uniform policy, very similar to PS 89. And actually, I'm sorry. I apologize. They did not have a uniform policy, which is really important. Okay, the school did not have a uniform policy, so they were wearing things that were not threatening, but speaking out against basically the Vietnam War, and the school expelled them. All right, the school expelled them, and basically the students were able to take this case to the Supreme Court, and basically says students have a right to freedom of expression within the schools as well. So if you want to wear your hair a certain way, if you want to wear a shirt that says something, that's fine. Now, within the school rules, like our school, if they say you need to wear a uniform and it's written in their school rules, then Tinker versus Des Moines does not apply. One of the first schools a student taught at was a private Catholic school, and girls needed to wear their hair a certain way. Guys couldn't wear earrings. They needed to be clean shaven. All right. Now, you do that in PS 89, you could kind of wear your hair wherever you want. No one's going to bother you. But in this particular school, they had certain rules where you had to dress a certain way as well. All right, so students have a right to freedom of speech and expression within schools, and this has to do with the students' rights here. Brown versus Board of Education, we've already done it, desegregated all schools in America, and obviously gave African-American students the opportunity to get the best education they can. All right, but I want to now focus on Roe v. Wade. I want to spend just a little bit of time of it, and this is actually what we're going to do. This takes place in 1973. It has to do with the women's right to privacy, okay, and but it goes beyond that, and it's all centered around abortion. Okay, do women have the right to have an abortion? It's a very complicated topic that, I mean, if you poll Americans, it's split right down the middle. Half will say yes, women should be able to have abortions, and some will say no. Okay, and there's a lot of gray area in between. So let's first start with this. I'm just going to read this to you. All right, get you some background on the case because this is something that is still, widely debated today. Where something like Miranda versus Arizona, Gideon versus Wainwright, they're pretty much set in stone. All right, but this one's still very controversial. All right, so let's just do a little background. In the second half of the 20th century, people's ideas about sexual relationships began to change and become more liberal, or another word, more open. Women could get birth control more easily, some states, and some states made it easier to get abortions. So you have a state like Alabama. If you were pregnant there in Alabama in 1965, you would not be able to get an abortion legally. But if you were in Massachusetts in 1965, you were able to get an abortion. So this is all goes back to the 10th Amendment. Abortions were never written in the Constitution, and I shouldn't really take this for granted. Abortions are when basically a woman wants to end their pregnancy early and not have the child. Okay, and it becomes very tricky because a couple things. How late are they having the abortion? Is the child 9 months, almost close to being born, or is it something really early on? All right, so it becomes very controversial. So it was a state issue. So some states allowed abortion, some states didn't. And this became a now federal issue because the Supreme Court's now going to make a ruling on it. So when the Supreme Court makes a ruling, every state needs to follow it. All right. However, these changes also created problems. Some poor women who lived in a state that outlawed abortion could not travel to get treatment. So if you were a poor woman in Texas and the closest state, let's say, was Colorado, but you couldn't afford to take a plane or travel to Colorado, you couldn't get an abortion. Some people said that this was not fair. Abortion laws were sometimes vague, so that doctors did not know they were breaking the law. Also, some people that said the government should not tell people what to do in sexual relationships. They said that this was an invasion of privacy. Okay? The U.S. Constitution does not clearly say that there is a right to privacy. However, the Supreme Court had said in other cases that a person has a right to privacy in particular places, like the home. In the case of Griswold versus Connecticut, the Supreme Court did not want unity to know for the regions. The Supreme Court said that Connecticut could not stop married couples from getting birth control. The court said that the families have a right to privacy in their decisions about having children and sexual relationships. The court said that privacy was a basic value that is important for all the rights in the Bill of Rights. Okay. So let's now go into it. So Jane Roe, which is not her real name, she was an unmarried person and she got pregnant and lived in Texas. She wanted to have an abortion, but according to Texas law, she cannot have an abortion unless her life was in danger. Okay, so if the mother in Texas, was getting sick and the baby was causing that, then obviously they would allow to have an abortion. But if they just wanted to have an abortion because they did not want to be a mother at that point or raise a family at that point, then they couldn't do it. Roe challenged the law by suing Wade, the district attorney where she lived. Okay, so this became a major Supreme Court case. Roe argued that she had a right to privacy and should be able to decide whether to have an abortion or not. She argued that the right to privacy comes from combining several other rights listed in the Bill of Rights. The state argued that the right to life of the unborn child is superior to the right of the life of the mother. Okay, so this is really the whole argument. Okay, if you ever get into an abortion debate, it's going to break down into this. Okay, someone who is for abortion will say, you don't have the right to tell the women, what to do with her body. That's pretty much the base of an argument. And the person who's against abortion will say, we don't care what the woman does with her body. We just care what happens to the life of the unborn child. Now, if you're someone who does not consider the fetus or the child in the mother's womb a human life, if you don't consider that a human life, then of course you understand that abortion, okay, you would probably be for abortion. But if you consider that person or child or fetus or a clump of cells, whatever you consider it, in the woman's body as a human life, well, then this could be looked at as murder in some ways. All right, so it's a very complicated and deep topic that people very much disagree on. The state also argued that this is a topic that should be left to legislatures to decide how to handle. A 3-judge federal district court ruled the Texas law unconstitutional. The case was then appealed to the U.S. Supreme Court, and then eventually this is going to take us to right here. All right, the Supreme Court would rule that abortions are legal in the United States, okay, and provided women with more privacy at this particular point in time. So what that means is no matter what state you're in, if you are a lady and you want to get an abortion, you are allowed to get an abortion, okay? So this is usually a pretty controversial topic. I remember the last couple of years, we had a little time at the end of class, and basically I drew a timeline on the board. And I basically put, okay, who thinks all abortion should be legal? Who thinks all abortion should be illegal? And what we start to learn is pretty much no one thinks all abortion should be legal. Okay, there are certain circumstances where that can happen. And basically, we have on the other side, all abortion shouldn't be legal. So my question to you is, where is a particular place where abortion should be legal or where it shouldn't be? And usually it has to do with time. Okay, it depends how long the baby's been in the mother's womb. Okay, many students said, okay, should it be 3 months? Should it be 4 months? Should it be 6 months? Should it be 8 months? Okay, and everyone has their differing opinions then. All right, if you think the abortion should be legal up for the first 3 months where the baby's really not fully formed yet, that's fine. Okay, but some people may think 8 months, 7 months, and it becomes very controversial. So it's very tough to have a discussion without, being with you guys in class. But this is a controversial topic. It's something that as you get older, you're going to start to have feelings of. But for now, maybe just start to think, how old should the fetus be before we stop having abortions? Because there's a number in someone's head. Some people say, listen, as long as that umbilical cord is kept with the mother, it's the mother's right to choose what to do. Okay? And then there's some people that will say, the second there is conception, we shouldn't have an abortion. All right? But the majority of people are somewhere in between. All right? I think usually the most popular has to do with doing it before the end of, I believe, 4 months. If an abortion is done after 4 months, you start to look inside the sonogram and you start to see that starts to look more like a human being. A lot of people are less okay with it. All right. But everything before that, people are usually more okay with. All right. And if you may hear in politics today, this politician is going to want to get rid of Roe v. Wade, or this Supreme Court justice is going to get rid of Roe v. Wade, and they're going to try to stop abortions. Remember this, okay? If Roe v. Wade is overturned, it doesn't mean abortions will stop. I need to make this clear. All it means is the states will then have to decide if they want to have abortions again. Okay, so it takes it from a federal issue and makes it a state issue again. All right. What I want you to do now is I'm going to grade this as a mini quiz. I'll give you 9 Supreme Court cases we've worked on in the last couple of months. All right. Match up which one is which. Use a Supreme Court case, and that's what your lesson is for today. So have a great rest of your day, and I'll see you guys tomorrow. You will take a test, and then believe you're going to hit Memorial Day. So I hope you guys have a great break. Enjoy.